deviation in moment question is okay. If it's a lengthy, long, personalized question, maybe we can just reserve it to later,
Correct. Yeah.
Yeah, I think it's a good suggestion, Arif.
Okay. So as long, yeah, let us just hold the questions to the end. Let's get started.
Yeah.
Okay. So
In
last
fact,
week,
Dharminder has to not answer if somebody asks. He has to control. Otherwise, he starts answering. The question will come,
right, okay. So last time there was some confusion, which I had to go back and brush up again on what is probate and what's not. You can imagine, like, if let's say, just to give you an example, probate is a process that transfers the asset from dead person's name to somebody else's name, okay? Meaning who the beneficiary is. So that process could be as simple as you already wrote the beneficiary information and everything else, and now the court has to just authorize saying it's okay to change the name of the company, I mean, the name on the account, and the executor takes that, serves it to the bank, and now bank changes the name from one person to the other. That can be as simple as that. If let's say it's a home, home is one person's, on a person's name. Well, it needs to go into another name that a will would have specified who the beneficiary is. So the act of it going from one person's name who is deceased into another person's name, as recognized by the court, is the process of probate. Okay, that can be as simple as everything that's written in the will, thereby they have no ambiguity, thereby they'll just, they'll accept by the certification or whatever. Person A is deceased, person A wanted it to go to person B, now person B is a legal entity, legal authority, legal person, it's not minor, all that, some legality that they check through, and they authorize it. Now you can take it to the closing place and then change the name and serve it to the township. Now it's in your name. That whole act is the probate. Okay, so there could be tax consequences. There is not. Sometimes, if it's clearly written, then there's no ambiguity. If not, if somebody were to be, challenging it, all those ensues from that act. Okay, so the issue of probate is.
Can you please put in slideshow mode? That may be better slide.
Okay, this is better?
Yeah, okay.
Okay, so because the probate is an act of somebody having to again validate, again go through the process of, making sure what you're asking is what it is really indeed being asked for, and the next person is what. So because another person is involved, it's subject to somebody's interpretation, somebody's this, somebody's that. The way to avoid all of that is, let's say a TD Bank account. You could actually today go to TD Bank and change there's a process, what's called a pay on death account, meaning the person B goes to TD Bank, serves the death certificate, that alone triggers the name change into persons B. There is no act of probate, there is nothing. So you don't have to go to court to serve any letter. Now, if the bank doesn't agree and they say, well, I don't like the death certificate, that's a different act. But 99% of the time, if it's an indisputable death certificate that you're presenting it, boom, they change it. So because it's that easy, it's better to do it that way than having somebody else, like from a court or court authorized person, get involved in validating it. Now the bank is going to take its own time in doing it. So that's how you avoid all that process. Joint ownership is another one that we talked about last time. So now walking the process through is, what is estate planning? Estate planning is about transferring of assets, not your income. Meaning, if today we are earning all the money, every year we're generating the salaries and income and all that, that's not what you are allocating to say X amount of my salary goes to a beneficiary. That's not part of the estate planning. It's about the accumulated wealth, accumulated assets, tangible or intangible assets that you have that you are planning. You're writing the instructions. You're putting them in. How do you want to address it? Is what's part of estate planning. So when it comes to income, estate planning has no control over it. It's some other issue, because once the person is no longer there, that part doesn't exist. It's the asset that the person leaves behind for which the estate planning speaks for. So the reason for why the income is not part of it is it can only be sometimes left to your spouse based on if it's a pension or whatever. The assets you have complete control over in the estate planning. Capital gains taxes are usually lower. We talked about that last time. We can trade or give our existing stuff to other people and change its nature in the way you will be planning to give, all of that. The assets that are transferred outside of the will, meaning today you don't even plan for anything. And sorry, I shouldn't say that. Today you didn't write anything in the will. That means if you had no assets that day for somebody to decide what do we do with it, then the need for a will exists. If you had already planned every aspect of your assets that go to who, and you already made provision of legal transfer already. In other words, not just writing your intent of saying, this house goes to my son. Well, that's not enough. You got to make it a trust that triggers, and the beneficiary is him or her, and then the trust automatically transfers over to the beneficiary. So the triggering of action for the change in name happens automatically if it's part of the trust. Whereas if it's will, somebody has to execute it. And the thing with will is it's about knowing who receives the property at the moment of death that is left behind, that's left over. Okay, so in other words, if you planned it very well, there is no property left over, then there's nothing to be for the will to do or to act on. So okay, as part of the will, what's not transferred is wills do not transfer property that has a successor ownership that is already known at the moment of death, which is also a reverse way of saying, if you planned well, you don't need to have a will for that. Meaning life insurance is already spoken for because the beneficiary is already written much before, right? So the life insurance just automatically kicks over to the beneficiary. IRA, 401ks, bank accounts, the same thing. 401k has a special rule. Somebody asked me last time, 401ks, if they are company-sponsored plans, because 99% of them are, companies get to provide the order of who gets recognized, okay? Many companies, they just standard adopt a template plan that is floating around by these third-party administrators that are required by our IRS to be in charge of. And typically, I would say 99% of them, is they don't care about what the beneficiary is. They automatically recognize the spouse, which is a very critical thing to understand. If you thought the beneficiary is my, let's say I wanted to leave it to my daughter. Beneficiary, I clearly write it down. Beneficiary is my daughter. It doesn't matter. Beneficiary is the spouse in the company 401ks. Again, to be clarified, as I said, 99% of them are. Unless in writing, the spouse writes and recognizes that she has no claim. So in other words, if today my company 401k, if I want to transition over to recognize my daughter as a beneficiary, it's not enough to just go write it down beneficiary as my daughter. I have to do this extra work of getting my wife, the spouse, to sign over an acknowledgement saying that she has no claim on it, that she recognizes the beneficiaries that I have put in there. Both of them together give the ammunition to the company at the moment to say, no, you wrote it already. If there was no such thing, spouse can go move the court, thereby serve the letter to the company, and the company is obligated to provide to the spouse, including the new spouse. Remember that. That's another one. Meaning, if somebody had to go through, divorce or some other reason, and then now you have a new spouse has a claim. Okay. So anyway, so it's something to think about. So once you guys know the rule, you'll know what to do. Joint property with the right of survivalship is another way, meaning if there's a house and then or the brokerage account and bank accounts, all of those, if you open it up with a joint property with right of survivalship in it, meaning if I could be saying my name and my daughter's name, sometimes it's and, sometimes it's or. You got to be careful with asking the bank, how do they recognize it? Sometimes it's and/or because that's term of art. Either way, the bottom line is that such an act will automatically gives access to the survivor. They don't have to go through all these going to some other authority to say, now I'm the one who now gets to be the beneficiary because it's already spoken for while the person was alive. Transfer on death and interest for accounts is another way of saying it. It's the same thing. It's the way the accounts are opened or recognized by the bank, the financial institution at the time of doing it. Trusts and contracts are not part of the living will, meaning if you were to have a prenuptial or partnership agreement that clearly says how something has to be divvied up, that's not recognized as part of the will. So those are already taking the precedence over how those things are done. In other words, you're only saying what you want to do that is yours. In other words, if I want to say, I want to give Brooklyn Bridge to somebody. Well, I didn't own it today. It doesn't matter what my will says, whether I want to give it to somebody or not. Okay, so last will or testament, which is, it's an original written or typed document signed by you, witnessed by a disinterested party, that states who receives the assets still in your ownership after the death, and names a legal representative, meaning executor, to wind up your affairs, plus can name a preferred guardian for minors. And this is submitted to court that oversees the probate process. So again, it's like saying, because of this, now I want the ownership name for the house to change from this person to this person. And it's only active at the time of death, but only probated if money or guardianship needs to be dealt with. Meaning if there is anything left over is when this becomes even being useful, having been active. Okay. So what is transferred is will only transfer property that still you own after you die. Meaning if the will asks for, it's like saying reverse. We don't know who gets the property, so we must look into the will. So in other words, if somebody were to say, look, Mr. X is dead and we have the death certificate, what do we do with all his assets? Well, they're only going to look at those properties to know who gets what, first by looking at the will, and then thereby what is left over, then they'd see what to do with it. The bank account, car, home solely owned by you, stuff like that, anything that's there. One thing that is a convoluted logic to use and thereby never use is to say the beneficiary is my estate. In other words, you're basically saying this house, this car, beneficiary is my estate, and the estate now has some other beneficiaries. That's a very complicated way to execute, subject to lots of troubles. It's just left easier to say, don't do it, thereby you won't have a problem. Okay, now probate versus administration. This is if you have a will, the process that takes is the probate. Responsible party is the executor, meaning who you assigned or recognized in the will. So I could be saying my brother, right? And who gets what is your choice because you're writing in the will. Now, if you didn't have any of that, the legal process that takes that occurs is this, that somebody is going to say, well, this is the death certificate that Mr. X is not there anymore. But I'm his son, I'm his brother, I'm his cousin, I'm his this, and thereby I'm entitled for this. So for that, they would have to go move the court by presenting it. The court will validate, authenticate, but first by making sure there's no will, and then they'll assign an administrator. As you can see, this is getting complicated already. And the minute the administrator is set up, you're thinking you're already losing half the money already. And who gets what is by the order that the state recognizes. Each state has their own order. Most of them probably are same, but I just want to say that. If you have no will, who receives the state? The order in New York State, I just picked up that, is spouse gets 100%, spouse and children, if you have it, it's 50-50, thereby, spouse gets 50, and then whatever, children gets 50%, then grandchildren. That's the order in which they would get it. In other words, if you already have a spouse, that's it. She gets 100%, there's nothing else. And if the spouse and children are there, only children are there, there's a whole precedence with how this goes. If nobody's there, New York State gets it. State's priority controls a lot about the will, meaning who gets what money if there is no will is decided by the state. Who gets put on notice if there is a will is also state's priority, meaning if there is a will, state would serve the notice to all those people. Of course, the one that you would have taken the name. Also, if the state recognizes next of kin have to know, they may even say that, because next of kin may want to challenge the survivability of that will. Okay. Nonetheless. Now, if there is an executor there, then it becomes that much less and less that all these come into fruition, right? Because the executor will be the one saying, here is the will, here's the death certificate, I'm going to execute it, and then state will authorize it. It's like a rudimentary form to authorize it. And then you just execute various obligations the person may have. Who has the best right to serve as executor or administrator is again state controlled. You get to control it if it's in the will, but if, let's say, you took the name of the person and that person is declared insane, well, now you got a problem. And state also has an order of who gets to legally contest the will. Okay. Who is denied in the state will for you. So in other words, they are automatically out. Is life partners, friends, those people not in line in the property list, as in stepchildren, not adopted children, all those, organizations, institutions, pets, business partners, specific gifts to specific people, these. So state already covers you up that other people cannot even just come and contest just because they feel like, they can get some money out of it. All right, so what does the executor do? Executor steps into your shoes to wind your affairs up. So if, let's say I were to go into India for 5 years, well, all the various things I may want to be finishing it up or closing it up because I'm never coming back, let's just say. There are lots of things that you would like. If you have a car, you're selling it, you pay the loan off, your water bills are paid, you close the house, you sell it, or you give it to somebody, all those things that you would have to be thinking of doing. It's just that instead of me doing it, now an executor would do it as if to wind the affairs off. They'll deliver the will to the court. They collect all your probate assets, meaning the assets that are still unaccounted for by you, meaning unaccounted as in beneficiaries and stuff like that are not already listed. Pays the funeral expenses, pays the creditors and taxes, meaning all the obligations that you still have to wind down your business, because what is left over, what can pass on to the beneficiaries is only after your affairs are closed up and spoken for. So if there are any medical records, the person has now access to it, meaning today you have a HIPAA rule that you can control who has the access to your medical records. But the executor on that day now has the access to the medical records. And the executor can bring a lawsuit. They can clean out your closets. Then they will give money to the beneficiaries. Order in which they'll pay would be the immediate obligations and the obligations that are needed to be satisfied before the will beneficiaries kick in, as we went on here. Now, if you were a survivor and you're not in the will, it's for you to be contesting that, it needs to be in writing, much better. There are some states that recognize word of mouth and you would have a lot of complications to prove, but it's always better if, let's say, I were to loan $50,000 to a friend and the person is doing whatever, working in Dunkin' Donuts or something. But if I don't have it written down, when that person is no longer there, I have no claim to go and then say, well, I gave him the 50,000. If I didn't give it, he couldn't have bought Dunkin' Donuts. None of that can work. But there are complicated way to get around it, but it's better to think that it's not. Now comes segue into estate planning and the need for it. When the assets are to be transferred over, okay? When a person dies, their assets could be subject to estate tax, inheritance tax on the value that exceeds the threshold amount. Okay, now what that means is in the will, if let's say we were to be talking lots of assets, house and gold and cryptocurrencies that are exceeded in the value, all those, if before the court recognizes or authorizes to transfer over to the next person, it is an act that triggers taxes subject to this slide that we're talking about, meaning when the total assets exceed a threshold amount, the estate itself has to pay the tax. What is left is what goes to the beneficiaries. In other words, if let's say, I'm just saying, let's say threshold amount is 0 and you were to be transferring the house. The value of the house, let's say, is 700,000. That act of transferring over to the next person, there is a tax due right there, which is 40%. that 40% has to be paid by the beneficiaries or the estate or the executor before the beneficiaries can get their hands on it. You can see already what I'm saying here causes a distress sale. There are a lot of people who didn't plan right or have this issue come up and they go, well, my father was living in this house for 40 years. Now all of a sudden, I had to pay X amount of money. I don't have it. So we're just going to sell it. Now, there comes the problem. If you're in a hurry to take the ownership of that house, tax is due right away. If you can plan better, that tax that could have been due can be spread over for a long time. Okay? Now comes, what is the threshold? But before that, this threshold amount right now is set up to be about 11.7, let's say $12 million per individual, and couple is about 24 million total. And each year it's kind of goes up and up. This used to be about 6 million before 2017, before they did this 10-year tax overhaul that they did. So if we are talking all this back in 2016, for individual, that threshold amount was 6.4 million. Now that is 12 million. For couple, that threshold together was 12.8 million. Now it is 24 some million. Now, this new rule of pushing the threshold high to 24 million expires in 2026 because it's only 10 years that they could do. So under the current law, the 24 million threshold for a couple is going to expire, and then we'll go back, unless some changes are made, down to 12.8, the way it was before. Okay. Having said that, there are just 5,500 of the nation's 2.7 million estates were subject to estate tax. In other words, the people who plan these who go through estate planning, who thought that they need to go through estate planning, because not everybody needs to go through, to have that kind of thing. There are 2.7 million estates in America as of 2016, of which only 0.2%, meaning 5,500 estates, were subject to estate tax. As you can see, if you can plan, you can save 40%, pretty good. And as you can see, there must be so many avenues. If only 0.2% of the estates are paying any kind of tax, that means there are so many ways to play this game, legal ways to play this game. And we'll go through various lanes in which you should be restricting yourself to, but then it opens up. It's like this estate planning is like ocean. But as you can see, if the threshold was to be 6.4 million per individual, or married couple of 12.8, you needed some thought of what to do. But the need to do anything kind of that much goes down if you're thinking, well, the threshold is 24 million. Because it's like a curve, how many people would need the estate that exceeds 24 million. As you can see, the number goes down already. On top of it, there are more avenues that they opened up. Okay, so again, just 5,500 of the nation's 2.7 million estates were subject to any kind of estate tax. Only the portion of estate's value above lifetime gift tax exemption, which is the threshold amount we talked about, is subject to varying federal tax, which is 40% on 1+ million, meaning the first, let's say whatever the threshold amount is, let's just say it's 12 million per individual. From 12 million, if you're over by $2, you're over by 50,000, you're over by 500,000. It's not all 40%. It's like a gradually increasing sliding scale, but 1+ million tops off at 40%. So if chances of somebody exceeding, if your threshold is 12 million, being in 13 million, as you can see, most of the people, if you crossed it, you crossed it to 40%. Okay, that's where this thing is. So the surviving spouse is not counted in the total amount and isn't subject to estate tax. This is another interesting way to play the game, okay? Meaning, Elon Musk, with 200 billion, can pass on the entire thing to the surviving spouse, and they are not subject to threshold because they get unlimited marital deduction. But that surviving person going down, now it's a whole new ballgame. So the husband and wife can transfer back and forth, unlimited. And this, as you can see, the variables that are coming in is what opens up for various ways to play the game. AB trust, ABC trust, all kinds of things. Okay, so the estate tax is a liability paid at death on the total estate before distribution to its heirs. Okay, so that's again, it's an event that triggers, IRS is notified, tax is due, all of that. Now, there is a estate tax, meaning the person who is passing asset to the next person, that alone has to pay. But then what about the person receiving it? In a general way of talking, a company pays salary to an employee. Employee is paying tax on the money they receive. As you can see, the company also pays the tax on the money that they are generating in their own structure, the way that happens. So you can think of it like that. Estate is somebody who did whatever they did, generated the money, but then when they give it up to the next person, however they passing on, meaning however the company is paying you salary, that part is estate tax. That part is done. Now comes the inheritance tax. That's also very critical, meaning the person who is receiving it has to pay. Inheritance tax is the responsibility of the beneficiary after receipt of the inherited property, with the tax rate dependent on the familiar distance from the descendant, meaning kids have one rate, further you are, higher the rate is. Federal estate tax, federal government does not today have inheritance tax. There is state estate tax, there is state inheritance tax. Okay, again, if you can see, state and federal, two different entities, want to put their hand in your pocket. For the estate, you have to pay federal tax. There is, some states have estate, the states also have estate tax. Now comes the inheritance tax. Federal government has no inheritance tax, but some states have inheritance tax, okay? Some states have both, meaning estate tax and inheritance tax. Some states have none, hence the planning. Are assessed on the estate's fair market value rather than what the deceased originally paid for their asset. As you can see, this is another variable in the planning. There's a whole discussion about step-up basis. You probably hear in the news every time they're trying to, reconcile the budget or gin up the revenues for whatever the planning each party does, they're always talking about these things. There's a step-up basis. We got to plug in this. We got to play with the inheritance tax and all that. Bottom line is, when these are various variables that we would have to understand in planning it. Maximizing yearly gift allowance is another one. Setting up intentionally defective grantor trusts, I'll come to that, or irrevocable life insurance trust, which I'll come to that, may help avoid estate taxes, okay? Meaning what happens is the act directly triggers, and those assets are not counted part of your estate, as in they are not part of your threshold. As you can see, why people don't pay, when 2.7 million people could have had estates, these are the various places it leaks around, where if you didn't plan well, or you had so much, only 5,500 people end up paying. Estate tax. So I put in the state diagram here and various states that have it. As of 2021, 6 states have state inheritance tax: Iowa, Kentucky, Maryland, Nebraska, New Jersey, and Pennsylvania, depicted by the blue shade. As of 2021, Washington, Oregon, Minnesota, Illinois, Maryland, Vermont, Connecticut, New York, Rhode Island, Massachusetts, Maine, Hawaii, Washington, DC, they all levy estate tax, which is depicted by the orange color. The reddish is both, as in, I want to say this is Maryland, and there's another one somewhere, I forgot. Oh, here. No, there's another. There are 2 states that levy. The tax rate is typically based on how closely related you are to the beneficiary. So as you can see, why people now, probably it's coming to some of you, why people basically shift to Florida as part of their retirement. Okay, not to mention the weather and everything else, 0 income tax and 0 in terms of inheritance tax and estate tax. Okay. So how to minimize state estate tax? Each state may have different estate tax exemption amounts and varying tax brackets. Okay. Planner had to reduce gross estate value. Again, the gross estate value is something that, as long as you don't have in the estate, okay, or have the assets that are very depressed when going in. But at the time of distribution, because the step up kicks in other words, a house that's worth 100,000, boom, you put it in the trust. But it could be probably worth 2 million because it's been there for 20 years in there, right? So the asset is 200 for the calculation, but what they get is 2 million. Okay, now inheritance tax, if there was a inheritance tax anywhere else, they get assessed at the fair market value of what it is that they're getting. As you can see, estate is about what the estate has, but what the person is getting, which is inheritance tax, is based on the fair market value at the moment you're inheriting. Which again, if you planned it well, you're in Florida or something, now it doesn't matter. Consider annual exclusion gifts. There's 13,000 per person that you could be giving gifts to. And the person who receives it, depending on places, may have to pay tax, but you're exempt. So if, let's say, there's a house that I could be basically scheduling it 13%, 13,000 worth of house. Again, I'm making a bad example. Let's say it could be stocks. 13,000 worth of stocks that I would be gifting to somebody. I could be doing that. And that's how I reduce my estate overall value. But the downside of doing that is once you give it, person has it, that's it, you lost control. Again, that's the downside of that. Consider annual exclusion gifts, charitable trust, which is another one, qualified personal residential trust. I mean, these are all various ways to play around with. Bottom line is each of them come with their own issues of how much control are you losing, the flexibility that it gives you, what kind of restrictions it comes with. And because it's a tool that is used to minimize the taxes, it does raise flag and bring you under the purview of IRS to look at you one more time. So thereby you want to make sure it's up and up to the rules of what it is meant for, and that it's not abused, because IRS can disqualify some of those and then bring you back and claw back. There's all kinds of bad things can happen. Or the other one is, this is where the interesting, 99% of the people, okay, would benefit using what I'm about to talk about, especially if you have life insurances and all that. Consider AB or ABC trust based on, ABC comes in if the value is much more. AB trust or ABC trust that take advantage of the unlimited marital deductions to divide the survivor's asset to total value up to exemption from the estate tax. So in other words, how the AB, simpler example, trust works, or ABC trust works is, you put an asset into the trust, let's say AB trust. The value up to the exemption, let's just say A, is still in the trust. What is additional on top is on paper tabulated, but the overall value, case in point, if let's say $100 million, that entire 100 million can go to the survivor. But if you put it in the AB trust, advantage of what happens is the A, meaning up to the threshold value of that individual, is kept up as a separate column in the value tabulation. What's remaining is separated out. So case in point, 6.1 million is one, and then remaining is the B part of it. So now, up till the time the survivor is still alive, there is no tax due. Okay, that's the beauty of this here. Instead of, if you didn't do that, immediately estate would have had to be liquidated, the beneficiaries would have had to pay the tax, all of that. Now you're delaying it. By passing it on to the spouse, taking advantage of the unlimited marital deductions, the whole thing goes to spouse. But now under spouse, A is tabulated, B is left out. When survivor is no longer there, the beneficiaries will get the entire A passed on as if the person initially took advantage of their fullest threshold, because you can pass on the fullest threshold without paying the tax, and the B portion of fullest threshold gets passed on to the people. So now you can see both A paid no tax of estate, B, if never exceeded the threshold, never paid the tax, and A and B didn't have to pay tax for a long time. And when the survivor is no longer there, Now they are still paying the tax on both exceeded amount of the husband and wife together's threshold, which will be 24 million today, or let's say in 2016, it's 12.8 million. That is what will be subject to 40% tax. Okay, so the as you can see now, AB was that. ABC is A is set is pegged to the one person threshold. B and C, meaning ABC part of it. B and C is the asset that is still up till the threshold of the second person becomes B. The extra amount on top is C. Okay, so that's how A, B, C. When the person gets in, they get the full amount in terms of the taxation. An advantage of doing that is because there's a step-up basis for how the tax is collected. Or this is a lot of people do that. Consider relocating to a tax-friendly state so that you're minimizing the state, minimizing or eliminating the state income tax, state estate tax and the inheritance tax too. So covering the trust, what are the trusts? Trust is like a legal signed document. It names that names a creating, administrating, and beneficiary parties, stating the term by which the assets held by the document shall be administered. So in other words, today I could be saying 15 rental properties and this and that. They all go into the trust. And I could be basically saying they all need to be managed in a certain way. Maybe I want it to be, whatever the ways that I want it to be trusted, as long as administered, as long as it's legal. And you create a trustee for that, meaning who is working it, and then you're off. Now, including it could be a company that administers that, right? So when they do that, let's say Bryn Mawr Trust, when they're doing that, they're bound by the terms that you laid out in there. And then they just do that, and the beneficiaries will be passed on the money the way the document will talk about. This is while avoiding court oversight, because as long as it's legal, it's a trustee that's working it, which continues to exist after your passing. That's the advantage of these. So we could be setting something up and then see that it's administered in a way, and then keeps on going, because if it's an irrevocable trust, that you no longer have involvement in it. Or certain things can be set in certain way, and then say at the time of death, it triggers to exist. Until then, it's just on the paper. And that trust, when it comes to life, starts to work according to the terms that you would have said. And only impacts properties that is owned by the trust. So it's limited to the trust. So in other words, as you can see here, if let's say office buildings are part of it, they generally make an LLC out of it and then push it onto a trust, so that the operation is limited and it doesn't float up to the trust any liabilities, but then the governing body is from the trust working it. So wills versus trust is wills, they go to probate and it's a public information. So somebody can find out how the properties are distributed and all that. Burden of proof is on the executor to say that he is the executor and this is the legal will, which court would have to recognize and authorize and say, yeah, you're the executor. It's a slow and it could be expensive administration if the instructions and assets are very complicated. Requires the minimal mental capacity, because you're just You're just giving it out for the person to do it. You don't have to think too much to write it down. Just need to execute to be effective, meaning you just have to sign it and then boom, it's ready to go. Trusts are private, meaning the assets that are kept in the trust, nobody's going to know. That's one of the reasons that people put things in trust, meaning if the trusts provide you credit protection, if it's done right. So if people today want to sue me, they can find out from the public information various assets that I own, like let's say their house and this and that. But if I kept my house in a trust, they're not going to know, nobody's going to know what that trust, who the trust, the beneficiary of the trust is, and what are the allocations within it, none of that. They'll just know from the public records, such a thing is owned by the trust, and that's it. So it gives you that that much of protection against somebody going after the assets of the, all of that. That's one of the big reasons why people put things in trust. Burden of proof is on the contesting party. As you can see, one, they have to go find out what's in there, and then they have to contest. So it becomes a little bit difficult. It's fast and minimal administrative costs, because once trustees and things are set up, it's pretty much on its own way of operating. To set things up and make sure things are done right, you need good interest and capacity to understand the legality of how things go. You got to project a lot in the future to set up everything done right, especially if it's an irrevocable trust. You cannot change it. I mean, there are very extraneous conditions that you could go to court and get them to nullify it and all that. But let's just say for our reasons, it's very difficult to undo an irrevocable trust. So let's say I were to put my house in an irrevocable trust and I wrote all kinds of instructions, and then 10 days later, I say, oh shit, I shouldn't have done that. I'm sorry. I shouldn't have done that. I changed my mind. That's it. So, you really got to think through what it is that you're doing. Again, because of the advantages that it gives you, like what I was saying a couple of weeks ago, all these are like live electric wire with a 420 volts running through. If you're not careful and you don't know how to touch it, you can get burned. But if you know what kind of gloves to use, what kind of shoes to wear, you can play a game pretty good. The thing with the trust is you need to execute it and fund it. It's not enough to just create the trust. You got to put the assets in it. Only then the trust becomes effective. So whereas a will, you can just say, I'm doing this, I'm doing this, I'm doing that. I don't have to think about it. There's no extra work after that, but trust requires you to fund it. Who are the parties? There are three entities, I shouldn't say entities, there are three groups of people that are needed in the trust. Creator or a settler, meaning who is creating it. The one who is creating it is the one that's coming up with all kinds of terms and recognizes the beneficiaries and then what assets they want to put it in, and then they fund the trust, meaning they transfer the asset. It's like me selling the house. Instead of to a person, now I'm putting it into the trust name. It requires a trustee who manages the property and various things that you would have put in the trust and distributes the money to the beneficiaries. Beneficiaries are required also is who are entitled to receive the proceeds under the terms the way you would have said. So just to play it out, if let's say I want $10,000, you probably would have heard, trust fund babies. The way these things happen is somebody, that a grandfather or a father or somebody has set a trust up long time. Well, it doesn't have to be a long time, but let's say has set it up, and they transfer X amount of money into it. And let's say it's chugging along, 8%. It's making returns. It's making either they're putting in the stock market or whatever else they do under the terms that you would want them to invest in. You could be saying, I don't want, when this money is transferred in, I only want them to buy real estate and rental in a low income properties and Section 8. And when money comes in, after the assets expenses are paid up, that needs, I want it to go 10% to my daughter and 25% to this, and then 60% to charity, whatever the terms are. The trustee is just basically going to go through the formula that you put in, and beneficiaries will be receiving it. So under that example, somebody made the provision for these people who are trust fund babies to receive X amount of money every month. Let's just say it's monthly payment, whether they do anything or not. Okay. Now, some trust funds require them to do certain work, whatever, but you can see where this is going. Now, there are two kinds of things: revocable trusts and irrevocable trusts, to branch off. Revocable means you're basically setting it up, funding it. You can change your mind anytime. You can undo it, change the terms in it. It's as good as not having it. Okay. The revocable trust, literally, other than putting that in a good cocoon, just so that you're able to categorize it in a way, it gives you no credit protection. It doesn't give you much flexibility of any kind, but it is a stepping in the right direction. Meaning, you could be saying all revocable trusts at the time of death automatically get converted to irrevocable trust, because the person no longer is there to change their mind, thereby whatever the terms that were spoken last in terms of setting a document up, that becomes frozen and it turns itself into an irrevocable trust. So during the life, it's just there, but after life, it can give a lot of privacy. It's not subject to probate. So as we talked about the need for probates and everything else, and it gives you faster distribution, flexibility, that you get to decide how things go. Now there's no legal entity that's involved in it. There's nothing to prove. Revocable trust, as we were talking about, they can keep changing it. You can keep adding the beneficiaries. You yourself can be a beneficiary. This is very critical. One of the reasons, the advantage of credit protection that the trusts give is when you give up, you being the beneficiary. Meaning, if you want to be, let's say we put in $1 million and every month we want $10,000 paid out to the beneficiary. You could be basically saying, I'm the beneficiary, I get $10,000 every month. Boom, that's okay. But that flexibility of me being the beneficiary, when I'm the creator, I'm the trustee doing all that work, I don't get any credit protection for that. So the law does not give credit protection against that. So if somebody sues, boom, my $1 million are still there. Okay, now, if it is a irrevocable trust, meaning becomes private, I have no control over the asset. I can only be a creator, I can only be a trustee. I cannot be beneficiary. Very, very important in this. People get burned thinking that. There is no angle in being a beneficiary. There is no giving out to my cousin and my cousin gives money back. None of that. IRS is very, very onto these kind of things. So an irrevocable trust, you give up being a beneficiary. Now, if you come back and go, well, I trust my daughter so much, she kind of, pays up all my expenses every month, so I can make her the beneficiary. It's as good as me being it. Okay, if you trust the person. but you legally cannot be. Now, in US, luckily, they recognize the kids as a separate legal entity. So if you have trust, you could be making your daughter the beneficiary and then do all that. In India, that becomes a little bit difficult. They're changing the trust laws in India too to kind of mirror what goes on here, in US. But there, you could be creator, you could be trustee, you could be beneficiary for some of the things. But it's always better, clean and clear, if you're not the beneficiary, if you created the trust. Just because whether it's today or tomorrow, as you can see, the protection cannot come if you're the one who's benefiting from it. So somebody's going to plug that hole in, whether it's there now, as somebody was talking in the Indian trust presentation, trust laws there are changing. Some of them may get grandfathered in, meaning if we were to take advantage of what's in today, set the trust up in the way, we are the beneficiaries too, that gets carried forward, but they may plug the hole pretty soon. But that soon could be 10 years from now, but whatever. It is part of the lingo they're talking about. So why irrevocable trust? It's a credit protection. That's the main reason why anybody does that. Reduces your estate taxes because it gives you a step up. And you can procure, this is where it gets complicated, government benefits. These are all legal, by the way. So, if you are sick or poor or disabled, there are some benefits that you could be getting it because you would have transferred the money out to the irrevocable trust, thereby you yourself now don't have the assets because some of these programs look at not just your income, but your wealth. How much do you have assets? If you were to be making an irrevocable trust, you now legally do not have assets. Thereby you qualify some government programs. All right, so you must give up some control to get these benefits, i.e. trust can be changed. We talked about it. You cannot both be trustee and beneficiary. This is where we were talking about. If in the interest of time, because we are at 9:08, if we want to close by 9:30, we have 20 some minutes. This is a good segue to kind of stop if we want to and take the questions and see if anybody has any interest, any questions. If there's any time left, we can come back to this because medical trusts are kind of complicated. You got to know what you're doing. They're all centered around reducing your assets to a level that is less than what the programs look for so that the benefits that you get, you can, one, qualify for the benefit, and then what do you do with those benefits? It's all centering around that. So I'm not sure how many of us are interested in, but it's there. Again, we'll put these slides up so you guys can go through it. All right, so anybody has any questions?
There is a question on the chat.
Yeah, I didn't see any of that. Okay, hold on. Let me maximize it. What? I don't know where to get the chat.
No, it's okay. I think we can move on. I think.
Yeah, what? Can you read out the question for me, please?
Yeah, the question is, do we have to understand the estate tax? It's when it is applicable to only to few of us. Yeah, I think that's a good
Well,
point.
in a way, as you can see, 6.5 million was the limit not long ago. It can even come back to less than that if it is that, some administration thinks that, that's the way they can get the money. I mean, as you can see, it almost happened, but it didn't. They were going after wealth tax, meaning just to maintain the wealth of certain number. Today, that number was obscenely high, so people didn't want to complain about, but they did go there. Those kind of things, that means, it's like New Jersey is a poster child for my example. Whenever New Jersey considered millionaire tax, meaning if you earn $1 million that year, you paid extra money, not just your state income tax and all that, but you paid extra money. Well, everybody was like, no, it's not going to apply to me when I'm not going to be a million, earn $1 million in 1 year, not millionaire. It's $1 million in 1 year. Well, that passed. Well, it came down to 500,000. Now it's at 250,000. So as the administrations need money, this is the well they'll go into. So is the answer, do we need it? Well, we probably don't need it at this point, but it's always better to understand. Case in point, if let's say you were to buy a $5 million life insurance, okay, it's only premium, you can buy anything you want. Well, would that just trigger the estate tax or not? If you planned well, no. If you didn't plan well, that will trigger the estate tax.
I mean, understanding, at least knowing about it is good. But I felt that not going into too much details on trying to find out what about how to avoid it, where to move to other state, all those things are not that much relevant to us, So I was just wondering whether, but I think from what I understood is that, this creating the trust is definitely, something very, very applicable to all of us, I think.
So, Dharmender, I just had a question pertaining to, the income and assets that you discussed before. I mean, I think there are a number of things that you mentioned where, the spouse is the automatic beneficiary.
Yeah.
I was wondering, in the unfortunate event that both you and spouse go at the same time, then what happens? I mean, does it go directly to the
Well, if the answer is if it's a account that you were talking about being, let's say 401k, right? Where you declared the beneficiary to be. So in the form, there's a clear mention of the beneficiary. Well, now if the beneficiary is not there, what do you do? Here comes the presence of a will. There comes the presence of estate planning, meaning we could have transferred the assets, the proceeds of 401k into the trust, thereby automatically they go to the trust. That's part of, if you didn't have any of that, then the state has a priority order. Who gets it? Okay, so
Yeah.
the kids and then the net gets casted wider and wider. Then the second cousins, then the distant aunt. I mean, short of nobody being around, then the state will get it.
Okay.
But to go back to Gopi's question, Gopi, one of the slides Dharmender showed, let me take a step back. Most of our assets, there are some exceptions, but most of our assets are either in 401k or IRA or Roth IRA, and our brokerage account in Vanguard or wherever it is. And Dharmender's one of the slides said that it goes to the beneficiary, and all these accounts ask for primary beneficiary, which is your spouse, and then it also asks for secondary beneficiary, which I'm sure you would have named your children. So if husband and wife die at the same time in a plane crash or whatever it is, then secondary beneficiary comes into play. Am I right, Dharmender?
Correct.
Yeah, right. Yeah, I understand that. I mean, I think it's more on things like the Social Security or pension. I mean, are those also where you actually specify your beneficiaries?
No, they don't go to
Secondary?
children.
Social
Security
Security kind of stops with the spouse anyway. So
they go to your spouse. If both of them die, that's it. Nobody gets it.
Right.
yeah, the income, part of it is not subject to planning. So that's like government program that stops with
Okay.
the spouse.
Dharmendra, I have one question and a follow-up.
Sure.
One of the slides where you showed that federal estate tax waiver or exemption threshold,
Yeah.
11 million, 23 million, or 6 million after 2026. The
Right.
first sentence said 1 million plus. What is that?
Right. In other words, if let's say the assets have exceeded the threshold, okay,
Yeah.
then the tax that the amount higher than the threshold is subject to is in a scale. It's like there's a table.
So graduated take.
It's a graduated table, but it's such a steep graduated table. Right at 1 million, it maxes out to 40%. So in other words, it's not automatic that estate tax is 40%. Generally, people say that.
Yeah.
99% of the time, if you exceeded the threshold, you exceeded by 1 million, So that's what, so
Okay.
just let's say you're only 100,000 more than the threshold. That
Yeah.
is 13%. I'm just picking a number. The other one is 22%. But pretty soon it becomes 40% and then maxes out at 40% once it crosses 1 million. So in other words, if let's say it's 100 million in somebody's estate or above and beyond the threshold, you paid 40% on that exceeded amount.
Okay. And the follow-up question is, just like the federal thresholds, which are high, like whatever it is, 12, 24, or 6 million, do some state also have the similar threshold, or they're all 1 million or?
No, they all have, inherent, when I say inherent, there's a flow down of the federal limit to them. Where they play the game is at the inheritance tax.
Yeah. So, but many states do have follow the same federal threshold?
Yeah.
Okay.
Dharmendra, I have one question.
Yes, sir.
I also heard that, if you create an irrevocable trust, it might work for long-term care planning. Do you have any knowledge on that?
Answer is yes, because what the irrevocable gives you is you're basically creating the beneficiary. You stayed one time, and the money that comes out to be paid out, it's a trustee who is doing that, right? So the irrevocable nature is not giving you any extra benefit because you're in hospital, but the credit protection and the automatic nature of it, meaning you're not the one there anymore. Meaning irrevocable is you're not the one day-to-day operating it. If you wanted to, you can, but generally people who set it up is setting it up and basically hire an advisor or somebody, and then they're the ones managing it.
No, I think there is something which we are missing here. There is something which you can do a irrevocable test with state. And we all know that, if supposing we require a long-term care, I'm not sure how many of us have already taken insurance against that because it's very expensive. Normally we don't take. And supposing you require a nurse to take care of you, I'm talking about extreme cases where we really grow old, we can't even move, and your children don't have time to spend on you. Like in India, we go through that stages where our grandpas and all that, they lived with us. And we have to even take care of their, but there it is cheaper. You can apply some, maid or something. But here, any nurse or something costs anything like $5,000 to $6,000, and it can be even more. So you are creating a trust in the name of state, like we are not covered under Medicare. But then if you take a trust like that for state, then in case you reach that stage, then your trust takes care of that. But I don't know all the implications of that and how to create it. But I believe there is something which food for thought or probably to look into, which can ultimately give us protection against long-term care.
And again, trust at the end of the day is somebody is operating it with your assets. In other words, nothing new gets created other than your assets.
No,
Right.
that is a special trust. That is not what you discuss. What you discuss. Your part you discuss doesn't even talk about that. That is a trust you create with state government. Like I created for New Jersey with New Jersey State, and then the New Jersey State provides that.
It's like a medical related, you're saying?
Yeah, there is some class, I think, which you create a trust for, which can plan for it. You look in Google, you might find it. I was just trying to read that. I can share with you later. But it gives
Yes.
protection against long-term care.
Hey, Dharmender, if I can ask a question,
Yeah, please go ahead.
maybe Vinod also can answer this. See, everybody says that the limit will come down from 23 million down by half come 2026. And if Democrats retain the White House in 2024, the chances are it will come down. So, what is the general advice nowadays in the trust business? Are they saying do the 23 million or 11 million transfer during the lifetime itself before 2026? Or is there any advice on not doing that and taking the risk that the limits will come down?
Well, the limits are at the time of death, not at the time of creation.
Yeah. Assuming that we'll be alive past 2026,
Right.
what are the chances of the limits coming down by half? And if you, before the limit comes down by half, when the limit is at 23 something, does it make sense to transfer the asset without paying estate tax to?
There are lots of other kinds of trusts. I only touched the very basic revocable and irrevocable. There are other kind of trusts today, okay, that gives you all the advantages
Oh,
regardless of the limit, okay, including, you know how we were talking about the trustee creator cannot be the beneficiary, right? There are trusts that actually are like that. I don't know if there was an article in Bloomberg. They somehow came across Nike owner. Somehow in some legal proceedings, it became public. Otherwise, those things are very private. And the trust that mechanism that he was using, turns out all rich people use. And then the article became, it's on the Bloomberg, you can actually see it. And it's called it's AGRT, GRAT, it's called GRAT, grantor created annuity trust, or grantor revocable annuity trust. What it says is, you today convert into the trust. This is the GRAT, G-R-A-T, I forgot what the GRAT stands for. Everybody uses it, okay? I mean, every rich person that you know is into 50 plus million has it. That's one of the standard loophole that, as you can see, they couldn't even plug it because that's how much it's used by all the rich people. And what it does is it transfers the assets, appreciation of the asset that the general premise is, let's say, you have Tesla stocks and then you put it in there. As long as you are the beneficiary to drain down the asset value in the term, it could be you can create it for 10 years, 20 years, whatever. During the term, you're basically required to take an annuity payment to yourself. In other words, it violates the first rule of what I just said, which is you are the beneficiary, right? But that's legal in that domain. But the entire appreciation from today's value, which you have agreed upon schedule to give back to you as a beneficiary, the entire appreciation goes to your beneficiaries tax-free, zero tax. So in other words, if today Tesla is 1,000 and in 10 years from now, it goes to 20,000. As long as you're draining the value of what you turned in back to you, entire appreciation goes to the beneficiaries. You can see how much aggravating it can be for people like us who work for a living, but yet there's a loophole that they all carved out that has nothing
My
to do.
question is, okay, billionaires can get their own
No,
advice.
you can do that. You can do that for.
No, my question is very specific. If your assets fall between 11 million and 23 million
Yeah.
in that range, does it make sense to do a lifetime transfer? That's all I'm asking.
Well, the irrevocable transfer is always tricky. Okay. That is the reason alone, a lot of people will say, do it as a revocable trust, let it trigger to become an irrevocable, even though you won't get the credit protection. There are a lot of other ways to hide it. And, offshore comes to mind, but it lets you change the beneficiaries, including yourself. And upon the death, it triggers itself becoming an irrevocable. Thereby, whatever the limit at that time is, it is. And unless you do this grant and other things that we talked about. But the thing is, the limit, you have no control. In terms of planning, we have no control over that limit. It can be higher, it can be lower. And as long as we do it, so, even at 2 million, we could be doing it. Why even wait for that long? Right? People do that for life insurance to be outside of the estate planning. So life insurance doesn't even come into that. And again, one of the reasons why the limit was increased was that argument that anyway people are finding ways to not pay. Why let the common man struggle to planning any of that? Why not just let them not do anything? As long as it's less than 12 million or 25 million, they don't have to pay. So thereby, either way, they didn't have to pay. They wouldn't have paid anyway, is what the argument was. So I can tell you from my personal advice that I am following, right, is the limit, irrespective of the limit, we are planning anyway, only thinking that we'll take advantage of the limit when it happens. Because it could be anything.
Thank you.
Dharmender, are there any recommended financial advisors that create trust for you? Like in Pennsylvania, who would I go to get started?
Well, the thing is, it depends on how complicated yours is, right? Most of the trust planning can end with a AB trust, which is kind of easy to set things up. All right. ABC trust is another one. And there are a lot of because this is such a template driven kind of thing, a lot of financial advisors just for the right to, manage your money for 1% or whatever, let's just say Fidelity or TD Ameritrade would have, they do that wealth management and trust setup on the side. Okay. Either they do it themselves or they may even tell you, hire this person who drafts it up and our people will oversee it. It's not that complicated. So if you do need names, I can give you, but I initially did it when my situation was not that complicated. Taking a name from my insurance guy that I have in the office. And, he was sharing the office premises with some X amount of people in their building. And, we just did it, right? As the situation got complicated, yeah, we changed it over, but that whatever the work the person did became a starting point for them to do it.
Dharmender?
Yes,
Following up,
Dharmender, you talked about revocable trust, irrevocable trust. Then you talked about AB trust, ABC trust. I'm confused. Is that in revocable itself, there are two AB and ABC. Similarly, revocable, they have AB, ABC.
Okay, AB and ABC are set up while you're alive, they start off being a revocable trust, but the assets will be funded at the time of the incident. Then they come to life starting off being irrevocable. Okay, so in other words, you're basically saying, I'm going to pledge my house, I'm going to pledge my life insurance, I'm going to pledge this. You're basically writing all that. You don't have to do anything, right? And that document is there, and it's just there in somebody's, paper, and you just file it. Somebody's possession, lawyers or who you trust it to be. Actually, you can file it too, but it automatically comes into living, meaning it triggers the trust that is set up as the AB trust, comes to life and becomes irrevocable on the day of death.
Do you have any idea about the cost involved in creating a trust?
Usually it's about $3,000 to $5,000. It's all
3 to
lawyer
5,000.
fees. Yeah, lawyer fees
Does it include your healthcare proxy, everything pretty much, or?
Well, no, that's a package, because healthcare proxy is more of a, X amount of documents that you would be coming up with to say, if this happens to me, I want, like my organs, I don't want my organs to be donated. Well, you're going to be saying that. Or maybe you do want your organs to be donated. You will be saying that, right? So that's a different document. Although generally the people who do all this are estate planning attorneys. They probably are proficient in doing all that in one shot. But it's a package deal. It's like if you're saying, I want to do this and I want to do that, the guy will be like, 2,000 here, 4,000 there. Okay, I'll do it for 5 together, something like that.
So once you create it,
have legal service benefits through your company. It's fairly simple to get that done through that.
Yeah, I would think. Yeah. Now, again, I would say 99% of us were pretty much going to live with a template that's already there. It's very few cases, I would say, somebody may need to tweak it or thereby get a hard and heavy lawyer involved.
once you create a trust, you have to inform, for example, Vanguard and Fidelity and your 401k, and put that under the trust name, because it's in your name now. Then you have to put them in the trust name. So do you have to contact them and change all the account ownership?
Right, and then the beneficiaries will change too, because now the beneficiary will be the trust, right? The assets will be transferred over. And then now it's the trust owns all that, not you, if that's what you want to do.
But the beneficiaries will be your children and you and your wife too.
No, depends on how you want the trust to exist. If the trust is something that, let's say you want to pool all your assets and create a trust. And then you say, I'm just giving an example, from the monthly proceeds that it creates, I want 4,000 to go to one person, 2,000 to go to another person. That the trust will give you that flexibility to define all of that. Whereas if you have a beneficiary, they just get it in one shot and that's it.
No. What I'm saying is create a trust, but then name the beneficiary under the trust to be your children, your wife, and yourself.
No, because then you're violating what the trust is. Trust defines who the beneficiary is, not an individual assets within it.
Now you can't say that 401k goes this way and then.
No, then you're talking will, not 401.
Oh, okay.
Can't have best of both.
Trust as a whole defines the beneficiary and the percentages of who gets what, right? You could be saying, from the profits that I get out of, life insurance proceeds, let's say you're saying we're going to buy a building. And from that asset, 2% goes to 1%, $2,500 go to another person. You could go complicated like that.
Now, what I'm saying is I put my 401k in the trust, say, trust
Yeah.
wants the 401k, then I can say that after my death, the whole thing goes to my wife, or if both die, 50% goes to one child, another 50%. You can't do that?
I would have to get back to you on that, because the thing is, you could do just on the 401k by itself.
I understand that, but once you create a trust and put the 401k there, then I don't know, are you saying that then you cannot name your children as beneficiaries? One of your slides said you can name the beneficiaries.
Individual assets, you can't really go, at least we did.
But I think once you have a allocation in your 401k, that always, because they even don't bother about your trust, they will just give it to they have to produce a death certificate, and then they become the beneficiaries. I mean, if you're husband and wife, the wife gets immediately without any problem. If both of them die, then the children get it. I don't think then trust will have supersede, or trust will have any meaning, because those are already in the you have already given the beneficiaries in your 401k and other accounts also.
No, I understand that. Now my question is, if those accounts go to the trust, I'm asking
trust-
how the
I think
beneficiary-
trust may be for other things, not for 401k, because 401k is already decided. I don't think trust will interfere with that.
The proceeds of the 401k, when you take it out, can be assigned to the trust. But just today, let's say you have a 401k in Vanguard right now. That cannot be changed over to your trust, because
Right.
you legally own that. It's a IRS related stuff. You can't change the name,
Yeah.
ownership name, but you can define the proceeds of it. So when you take the distribution, who gets the distribution? You could be
Now,
saying,
how about the non-retirement account at Vanguard? That can be put in the trust?
right, that have no control. That you could tomorrow change it. Yes.
Then to go with Vinod's observation, even that has beneficiaries stated, then looks like trust is not needed for any of those things.
No. Basically, your assets will go into trust, and it will go into a bank account. Let's just say Vanguard account that now trust in the name of trust. It's not like Vishwanath account is still caretaker of a trust. Basically, you're transferring the amounts, and now the new name will be Vishwanath Trust.
Then can I name the beneficiaries when I die? Can the trust?
The trust will have the beneficiaries. So it's
Yeah.
almost like saying you're transferring your account and your
I
money.
think it's worth employing a legal person and taking his help, because these sessions are good for introduction. But I think when you have to be specific, then better to spend that money, whatever is required. I mean, so in different states is different, but better to do that, and then you know all the implications. Because you can't have a trust without somebody helping you out, right? You have to get the help of some attorney to create a trust.
But still, think of it this way. You are basically liquidating your cash account. You're going and depositing it under trust name. It's a total different account, right? It's no longer Vishwanath account, it's a trust account. And that trust has the legal terms of who gets to be the beneficiary, and then under what percentages that you're thinking. So your account ceases to exist after that. Once
No, I
you
understand that. I understand that.
Yeah.
But then there could be beneficiaries of the trust account. That's all.
Correct. Exactly.
Yeah, that's what my question was. The original question was. Okay.
Right.
Basically, they are the trustees. There's nothing like beneficiary, I think. The trustees itself are the owners. Like if you have a trust and your children are trustees, they are
Yeah,
the
but they are
owners
the
of that trust. They
beneficiaries.
own all the properties, just like you. So there is no question of beneficiaries. They are not beneficiaries. They are owners.
No, it doesn't work like that.
No, they're not. I am the trustee he has the right to distribute.
Right.
but
Trustee
he-
is the
Yeah, but who is the trustee? Trustee, you are the trustee of your own wealth, and then you are
Yes.
transferring to
Yeah,
your.
you can be
It's
the-
not the legal person who is the trustee.
You can
Trustee
be
is
the
appointed by you.
right.
You can be the trustee.
Think of the trustee as a clerk who is basically following the rules you set up. It could be you, right? But trustee has no more work than a secretarial work. I'm just simplifying the word, okay? Beneficiary is the legal authority who gets any benefit out of the trust. So trustee cannot take $1 for himself if it's not already spoken for, or if it's not allowed to charge as a fee or anything like that.
But you are defining the rules of the trust.
Correct.
Okay. Yeah, a side question here, Dharmendra, and that is, you mentioned something about $13,000 a year you and your wife can give to each one of your children, and if you have 10 of them, you're distributing a lot of the wealth away.
Right.
But what are the implications as far as the tax to them is concerned? In other words, do the kids
Now,
have to pay?
it becomes a regular income for them. They have to pay.
Oh, it becomes regular income for them.
Yeah.
Okay. So that means they will have some kind of a so-called inheritance tax.
Right. You can think of it like that. Right.
Yeah. Okay. So regular income. Okay. So if you give it to a kid who's richer than you, then he might be paying more taxes on it than you are.
No. I thought the gift limit is up to that $30,000 limit. There is no tax to the recipient.
It's not an income. Only the gain they get from that may be income. But
Only the gain they get, because
Yeah. I mean, it would be difficult to, if you give a kid $13,000 and he's, you might put him over a tax bracket by doing so, and he'll be paying more money as a tax than sometimes you would. So,
no.
so-
See the 15,000 husband, 15,000 wife can give 30,000 to their children each year. But
Mhm.
30,000 is not considered income for the kid because it's under
Yes.
the gift tax threshold.
yes, I think that is correct.
Yeah,
I'm gonna
okay.
look it up, but I doubt, I didn't think, I thought gift tax is for you, not for the recipient, but I could be wrong. I'm
No,
gonna,
so it's not income for them. It's not income. For
It's not income for them, Dharmendra. I have been doing it for more than 15 years now.
them. Yeah. In fact, even 529 Pennsylvania says that you can give. It's not income for them either.
no, 529 is different. Anyway, but that's tax question. I didn't have to go through gift giving yet, so I didn't know that. I'm gonna find out. It's an interesting thought that a recipient doesn't have a tax implication, but
You know, Bala is right. I've been doing that too. Bala is right.
Yeah, we've been doing it for a long time, because otherwise, what's the point?
no, point is that you get to reduce your estate tax. Otherwise, think of it this way: if 15 of your friends are giving somebody some money, and now they have 150,000, is it a free money that they have to pay no tax?
Yes.
I doubt it. Okay, look, if you're doing it, then I would have to take it from you. But it's an interesting question. I'll check with my CPA guy, because that gives me some ideas for my daughter.
I think it's a good thing to do. The thing is, in addition to that, the limit of whatever 11 million, 5 million, it used to be only 2 million a while back. That is also not income, but that goes into the limit that you can give to your children.
Right, both together. It's the estate threshold includes the gifts, right? That's what you're saying.
Yeah, but that is different from annual gift limit.
Correct.
So Bala, what you're saying is if you've already given, say, for example, $1 million away as annual gifts to your kids, as far as your estate transfer is concerned, of that 23 million, that doesn't include the million that you already gave.
That does, it does, because in my case, I have transferred some to my kids earlier, and that limit is now 23 million. It will come down to 11 some million in 2026 if law doesn't change. But my question earlier was that if you have given up to 23 million before 2026, and then the law changes and brings it down, then suddenly the kid won't owe any estate taxes because you gave it when the limit was higher. Now the limit is lower. I think there is some nuances to that. My accountant has been advising me to transfer some to take advantage of this if you want to. And that's why I'm interested in this irrevocable trust and all that. And I'm not like the Nike guy, but so I'm not worried about that kind of a big complicated trust. But within the limit, for some people it might make sense to transfer more before 2026 if you expect the law to be more democratic and come back to half the level. That's all.
Yeah, I'll investigate and research a little bit. And that's an interesting concept, that a limit is a lifetime limit. That what if you exhaust it in year one, right?
You can exhaust it within your lifetime, and then whatever else your estate is remaining, if any, that becomes fully estate taxable.
Right. Then I'll read up on that. I'll send some links to all of us. I'll check with my CPA guy, right? And then
I have another question. This is pertaining to Pennsylvania. I was told that the Pennsylvania inheritance tax is 4.5%. But if your kid, my question is, if your kid doesn't live in Pennsylvania, if the kid lives in a out of state where there is no inheritance tax, then does she have to pay the inheritance tax of Pennsylvania because she doesn't live here, but you do, or when you die here, then how does that work?
while researching what Rich was asking me, I stumbled across a few places where they go through this questionnaire, right? And I'll find out. But definitely I'll have an answer. But what the gist that I got is the person who has to pays where they live, the state tax where they are living. The beneficiary, in other words, beneficiary can be in a different state. Trust can be in a different state. Thereby the person who's giving the gift can be in a different state. The person who's receiving, meaning the beneficiary's state tax, depend on where they live. Is how I'm going to share a link that I had. Okay, hold on.
I was told by my accountant that if the trust is in Pennsylvania and the beneficiary is out of the state, then if out of the state the beneficiary doesn't pay any inheritance tax, then the inheritance tax will be taken from the estate before it is given to the beneficiary. So Pennsylvania will take the tax whether or not your kid lives in Pennsylvania. That's what I was told.
Right. I can see that, because they would want people to keep paying the money one way or the other, and they'll find, every state will have one exception to the other, right? I mean, in fact, California had another one that you have to pay 10 years. Keep paying taxes for 10 years, even if you were to move out to Texas, because a lot of people are migrating to Texas. So they were saying, again, that consideration went away. It didn't pass, but they were seriously considering that you still will continue to pay at California taxes, even though you now are in Texas. You can see how arcane that is, but it all centers around they need to get the money because they don't want you to game the system one way or the other. So if they just sat right there and go, well, between the person who's giving to person who's receiving, if one of them is in Pennsylvania, boom, I need it. They could say that. And so every state is so I'm not sure about Pennsylvania, what it does. Of course, every, state is different and the taxes would be different at the time. And CPAs, probably can, have more definitive answer that is applicable at the time of when this happens, right? And maybe even planning around it. But my general sense always in the planning that I go is they would want your tax one way or the other. So just be ready that money you're going to lose. Now, something that you can do, plan it, and somehow you didn't have to do it, that's a bonus money that you got, because that's one way or the other, they'll find it and they'll get it.
Yeah, one of the things which Bala mentioned is very poignant here because, today's rules say it's 23.4 million. So let's say you max it out and you give 23.4 million. And then tomorrow, 2026, the number comes down to 11.7. So they can't say that you've exceeded the limit because you exceeded the limit when you didn't exceed the limit when the limit was something different. So therefore, retroactive, I don't think they can levy any kind of penalties on you retroactively based on rules.
Again, this is pure observation. Estate tax or no estate tax is decided at the time when the distribution is needed, meaning at the time of death, right? If I were to just guess it, just a smell test, my guess would be the limit applies on that year when it happens, not at the time that you distribute the money. That's how I'll be thinking. But that's an interesting angle to find out what if you max out now that the rules are favorable. And is that how the tax planning goes?
Bala?
Hey, yes, yes, Vish.
In your scenario, suppose say you are giving $1 million to your child. They have to include that 1 million minus 30,000 as their income. They have to pay income tax on that, even though there's no estate tax because it goes counted against the lifetime of 23 million. But that's an income for your child. They have to pay tax that year.
No. The whatever money you transfer as part of your estate limit is different from gift tax limit. Gift is something that you do every year, regardless of whether or not you have transferred your limit on the estate side. So in my case, I have done both. I have transferred some into an irrevocable trust, and I even put conditions that she can only touch the money when she turns 35 and all those things. And I have transferred some, and then I give annual gifts as well. You can do both, and there is no tax due for your child when you do that.
So what you are saying is, if it's a gift of 20,000 or 50,000.
13.
No. Let me my example. If it's a gift of 50,000, then 50 minus 30, 20,000 will be taxed. But
Yes.
if it's a 50,000 or a million, whatever it is, against the estate transfer, then you are saying that's not taxed for your child.
It's not taxed for your child. So your good accountant must do is transfer 30,000 as gift, the other 20,000 towards the estate limit.
Yeah, I hear you.
Yeah.
Hey, I want to make one point which is very critical for all Pennsylvania residents. I went through a case just recently where the inheritance tax for your kids is 4.5%, but if your siblings are inheriting, the inheritance tax for your siblings in Pennsylvania is a whopping 12%.
Yeah, they changed, they have a different number for how close you are considered to the person in terms
Yeah,
of.
if the person receiving receiving the benefit is your sibling, that money and the limit is only like $50,000 or $100,000. The limit is very, very small for the inheritance tax in Pennsylvania. Pennsylvania is not a good state for inheritance tax.
Go to California then.
They will socket you differently.
I know, but California has a lot of income tax.
Yes, we have a lower income tax, that's right. By the way, one other thing about Pennsylvania which is funny is that there is no limit on gift during your lifetime. So during your lifetime, you can give gifts to your kid without inheritance tax. So for example, if you die, then you pay 4.5% inheritance tax. Just moments before your death, you can give it as a gift. Then you don't pay that
But-
4.5% tax.
But I thought gift you can give only 30,000, you and your wife.
That is a federal limit. The 30,000 limit is for federal taxes. In Pennsylvania, there is no limit. You can give any amount of gift to anybody.
Oh, is it? Oh, I didn't know that.
So, but that's only for Pennsylvania. But you will pay the federal taxes.
Oh,
Bala, best thing is to move to Florida. You have none of that concern.
yeah.
Yeah, but you will have to be under DeSantis.
So for the gift, for the
Or
gift
not pay
giver,
attention to any of them because tomorrow there'll be somebody else. Weather is nice. You can be on the boat and water all the time.
I have a quick question. So the what is the tax benefit for the gift giver? Does it reduce the taxable like the
Your
gross?
estate will go down.
Only that, not for nothing for that year, right? Like does it
No,
affect the
meaning
adjustable gross income?
you pay, you can
No, no, no.
deduct, you can deduct up to 13,000 if you give it to somebody, and then you can, that's not part of your.
Does it reduce the taxable income?
No, you can't deduct anything from your taxable income.
Okay, all right. I'll double check. It seems like it. Yeah.
Now, there are programs for the state level that you can put it in. I'm not sure whether it couldn't reduce your taxable income because you still got to earn it.
Yeah, in Pennsylvania, for Pennsylvania tax, if you put it in 529, then
That's different.
Not educational and just a gift.
So in other words, because it's a quote unquote long-term retirement, long-term untouchable money, they're giving you the benefit of deducting the 13,000. Otherwise you pay, right? Otherwise it's not taxable. Right. So the answer is it's not taxable. Sorry, it's not deductible.
Yeah, it's not
unless you contribute to some special programs.
Got it. Okay.
I mean, look, a lot of these are interesting to chat, but every person's special case, it kind of requires a professional to address and give us a right opinion. But in the interest of, sharing knowledge amongst all of us who are kind of sort of a little bit know, but may not be 100%. But in terms of what's out there that deserves to be planning, and if you don't plan, what happens? In my mind, it's kind of very critical to understand, right? If we did nothing out of these 3 sessions, the converting all of the accounts to have a beneficiary next to them, or better yet, convert them to, some way that it's unambiguous, they don't become part of probate, because let's say we say, well, look, they're not going to do trust. Okay, fine. But attending on those accounts so that it's unambiguous. In other words, banks don't want to get into a lot of complications. If we give them instructions, that's part of already set up, meaning an account that's called I forgot what the name is. There's a special thing that they talk about, meaning you can designate what happens upon the death. Okay, and this is even beyond the beneficiary. It's called setting up death accounts. Hold on, I'll bring that up.
You're not talking about either or survivor, right?
Either or survival is one.
Mm-hmm.
That is like setting up a joint account. But there is another one, pay on death account.
Okay.
Okay. You could basically be asking them, what's the procedure for it? And when the account is converted like that, all the person, the beneficiary would have to do is to serve them the death certificate, boom. Without any other complication, manager right at the desk probably will even change it, right? Things like that. If you generally fall through the cracks, and it doesn't deserve to be some big time lawyer thinking about any of those, but regular accounts, company 401k is another one that I talked about. It's very essential to understand. You just can't name any beneficiary you want, because the rules that the 401k account planning that the companies have started, in other words, companies set up the rules, not the IRS, not anybody else. Companies can come up with any rule, and they say, this is our 401k, and here are the participants. And the participants have to abide by that rule that company just dreamed up. But it's very, very common, 99% of the time, they only recognize the spouse at the time of the death. So in other words, you could be saying any number of beneficiaries, it doesn't matter. So it's critical to know that. Reason is, how do you, if ever you want somebody else to be the beneficiary and you thought you just set it up for beneficiary, what happens? Well, there is additional step. You have to get the spouse to acknowledge that it's not, that the person is aware and had no objection for recognizing those beneficiaries, and you put them as part of the account. Things like that. So even if we didn't do the trust planning, with Nari, Bala, and Muthu working our accounts, maybe we all will have $50 million in our accounts one day. But until such time, at least these kind of things are kind of, good to have. It doesn't take much. It's one Saturday work, to just set them up and, just procure all the information, operating information, having assets, various places. Sometimes I know many people, especially in India, they just give it out to other friends and whoever on whatever the loan that they do, like hand loans. There's no anything. So at least you got to capture it.
Yeah. Makes sense. Thank you. Thanks, Dharmender. That was good. How come Nari has not spoken? Is he the sleep mode?
Nari left the meeting, huh?
No, he's there, but maybe he's in snooze mode. Personally snoozing, maybe.
Nari went to sleep.
Looks like it. Must be a long day for him. But I don't know whether when he shuts off is when the recording.
I'm just listening to you guys.
Oh, okay.
Yeah, T20 cricket is over, so Nari is.
No, because the recording has to come to a logical end only by him, I think. So.
Yeah, New Zealand is starting tomorrow.
Wow, is it, what time is it on the TV?
I think it's 8 o'clock, 8 a.m.
8 a.m.? Wow, okay.
Cool. This was great. Dharmender, Nari, everybody, thanks. Thanks for this.
Thank you, Dharmender.
All right, man, thank you.
Thank you very much.
Thank you, folks.
Thanks, Nari.
Thank you. No, great job, Dharmender.
All right, if you don't speak until Thanksgiving, I wish.
Yeah, no training session, no meeting next week because of Thanksgiving session.
Happy Thanksgiving, everyone.
Happy Thanksgiving to all. Enjoy and stay healthy.